Welcome to the Loud Little Ducky. Today in Owens v. Echard, we are going to go over motion for virtual conference. We've got our sonogram with a little burrito in there because that's what everybody's sonogram looks like, right? Gotta have them burritos. This was filed February 12th, 2024. So we're going back in time a little bit, but I want to try to get all these motions out. If we don't, and the settlement does get, if the settlement does happen, which aside from her admitting what she did and an apology, I don't see a settlement happening, but who knows. If that does happen, I won't keep doing past documents unless somebody really, really wants it. But we'll just go from these documents to whatever else is put out there between now and June 10th, either for trial or if a settlement is reached, if that makes sense. But let's get into this. Expedited motion to set virtual conference, status conference, expedited ruling is requested. Clayton Echard, by, through, and counsel hereby requests that this court set an expedited 30-minute virtual status conference. The motion is expedited as trial is currently scheduled for the end of February. In my raid, pre-trial issues must be addressed prior to the scheduled evidentiary hearing, including addressing the motion to continue an additional time. So, we watched the granting of this motion because they did have a status conference in February. So this motion was granted. They ended up having the status conference. That is the one where she signed the HIPAA releases and stuff like that. It might have been March, but either way, they ended up not going to trial in February. It's been moved to June. So let's go over what was said before that got granted. Petitioner has grossly exploited the judicial process by refusing to comply with the rules and legal process that she invoked when she initiated the underlying petition to date. Petitioner has willfully and wantonly refused to provide any Rule 49 disclosure, respond to any requests for production, and failed to attend a properly noticed deposition. Simultaneously, petitioner filed for motion for confidentiality and preliminary protective order filed January 18, 2024, to seemingly shield herself from any further criticism for her non-compliance, and deposed respondent when she refused to participate at the same time. So she didn't go to her deposition, but she went to Clayton's deposition. So they want Clayton to do everything and show up for his deposition and do stuff that he's required to do, but she doesn't want to do that stuff herself. Petitioner's perpetual disregard for court rules is exhausting, I would say. I feel so sorry for Woodnick and Isabel. Respondent's expedited motion to continue trial and motion for additional trial time, filed 2/6/2024, is pending before the court. Consistent with her historical disregard for court process, petitioner failed to respond to the email inquiry asking her position on the same and still not done so. While due process requires the court to grant the continuance and provide for additional trial presentation time, for this reasons detailed in the still unopposed motion, there is an urgency for a status conference to be held prior to the eventual hearing date. The antics from petitioner continue to proliferate, and it is clear from the communications as appended that the petitioner's most recently retained counsel, approximately the 12th in this series of cases, not just Clayton's case, is having challenges with client control that impact respondent's ability to access requested disclosure. As and for his expedited motion to set a virtual conference, respondent states as follows. On August 1st, 2023, Petitioner initiated the underlying action when she filed her petition to establish paternity, legal decision-making, parenting time, and child support, alleging that she was pregnant with respondent's twins after only oral. Respondent has consistently maintained that this alleged pregnancy was entirely fraudulent and that oral does not result in babies. 2. Petitioner's blatant refusal to provide any disclosure or engage in discovery must be addressed prior to the evidentiary hearing. During the nearly 7 months since initiating the action, petitioner's only evidence provided in support of her alleged pregnancy has consisted of fake sonograms and positive HCG tests. There is a history of the same in a different case. No medically verifiable proof of pregnancy that would satisfy the requirements of Rule 2, which petitioner herself invoked and has been provided, likely because no such proof exists. See also respondent's reply to petition's response to motion for sanctions pursuant to Rule 26. We've read that. Explaining that a positive HCG test is merely a sign of pregnancy and false positives can be caused by medications such as those associated with epilepsy and infertility. 3. Petitioner has provided no disclosures and continues to flout the rules of the court she invoked. Instead of providing basic discovery, she has filed board complaints, and sued journalists who have covered the story that she reported and with whom she actively communicates. Meanwhile, respondent has complied with all the requests for disclosures as required by rules and requested by petitioner. More offensively, petitioner has alluded to having the records respondent requested multiple times but has refused to provide access under the guise of protection and public scrutiny. Parenthetically, while claiming she needs protection, petitioner continues to reach out to media and self-publish 2 more Medium articles on February 9, 2024 and February 10, 2024, Exhibit 1. To be very clear, petitioner is claiming she cannot disclose records to respondent, but has recently, as days ago, is publishing articles about the situation. Notably, during respondent's video deposition on February 2, 2024, petitioner's counsel presented a highly redacted, 80% of words blacked out copy of medical records purportedly containing proof of alleged pregnancy. What the hell is something that is 80% redacted proof? Nothing. It proves nothing. It proves that you have a lot of crap to hide. When respondent's counsel asked to see the unredacted document, not to make copies or otherwise distribute, only view it in person to verify it actually existed, petitioner refused. She didn't want people to see what else was on it. Why? Who knows? She wants to say that's because Clayton and them are putting stuff out there that they're not, because everything that's been put out there is because she put it out in the public herself. Did Clayton go on biofiles and show some of that stuff that she had put out there? Yep. But she put it out there first. And he has the right to talk to people about this, to check with people. Hey, what do y'all think? Here's my side. Because she gets to sit here and scream from the rooftops her side to all those massive tip lines she talks to. But as soon as he tries to say his side, she has a problem with it. Only see my side of the story. Only believe me. Who cares what anybody else says? I don't care what anybody says. I don't care what Clayton says. I don't care what Owens says. I care what the evidence says. And I think most of us are on the same page. The refusal to allow respondent's counsel to view document ostensibly central to the foundation of this case only further exhibits petitioner's sanctionable conduct and wholesale inability to support the fiction of her alleged pregnancy. Petitioner claiming that she had access to verifiable medical records to support her allegations of pregnancy, but then refusing to make them available for respondents' inspection is a blatant act of disrespect to the court and the judicial process. She wants everybody to just take her word. That's not how any of this works. None of this at all. 4. Although respondent believes the alleged pregnancy was a con, scam, rerun, he needs access to disclosure and documents ostensibly in petitioner's possession. Petitioner's blatant refusal to comply with the rules of the court and instead push her own narrative has required further legal involvement in obtaining this information, which petitioner claims to possess. Yeah, I have all this stuff, but I'm not handing it over. I don't care if the court tells me I have to hand it over. I'm not handing it over. That didn't work very well for you, Owens, did it? Respondent has continuously provided petitioner with ample opportunity for her admit that she fabricated the entire pregnancy or to comply with the court's rules, only to be rebuffed or outright ignored. Exhibits 2 through 4 as a sample of respondent's efforts. February 5th, 2024. Since we have not received any disclosure from blank, the RFPs remained outstanding. The HIPAAs have not been executed, provided 3 times. The fatal death certificates, provided twice, not executed, and still need to depose her after she failed to appear at her deposition. We are going to file a motion to continue and a request for additional trial time. Yes, she's not done anything the court has asked her to. February 8th, 2024. You have not yet responded to our motion to continue and for additional time, nor have we received a written response. I am guessing that you are having something. Oh, this is client control issues, I believe. Let's see if I'm right. And I was right. Significant client control issues as evidenced by Laura's recent behavior in California and online. I appreciate that Owens is going to refuse, contrary to law and court rules, to provide actual medical records, as there are none that support her under oath statements. Assuming we'll continue to receive no disclosure from your client, our motion to compel is forthcoming. February 9th, 2024. Things just keep getting more ridiculous. Even after my email yesterday, there is another article by your client. Since Laura's bag of tricks tends to fit a pattern, we suspect the postings were a contrived plot to yet again request motion to seal. I appreciate that your client wants to view herself as a victim by the press that she incited and continues to stoke with her articles, but these postings should be viewed with several grains of salt. We personally tried to find the alleged postings, but to no avail. Should you be inclined to file anything further regarding the opacity of the legal proceedings that Owens instigated, please promptly disclose the alleged postings in a manner that complies with Rule 2 so we can access the same and properly respond to the court in kind. Petitioner now says she is no longer pregnant, but has failed to identify if this is a result of fetal death or the alleged babies have put up for adoption. See footnote 1. Notably, respondent attempted to register himself as Arizona Punitive Fathers Registry in the event that petitioner actually delivered twins and or is claiming to have put them up for adoption as a reason for explaining their non-existence. See respondent's notice of filing an affidavit of non-paternity. I am starting to wonder if I have actually read this before. Or I may have read this in one of my 6 parts in this, 5 or 6 parts in the beginning of covering this case if I did this, but we're just going to do it separately as well. As required per statute, and blank HIPAA releases have been provided to the petitioner 3 times and have gone unacknowledged. See Exhibit 2. If impossible from oral, petitioner was actually pregnant, delivered twins, and or suffered a miscarriage post 24 weeks gestation at any point during this proceeding, she would have verifiable medical evidence. To date, no fetal death certificates have been executed, no confirmed medical evidence has been presented, and petitioner has continued to claim protection. while reaching out to media directly. For all respondent knows, the imaginary twins are buried at a horse ranch. Oh, that's a good burn. That's a good burn, wouldn't it? Good job right there. 5. To discuss the outstanding motions as well as blatant absence of disclosure/discovery by petitioner, respondent requests this court set an expedited status conference for 30 minutes. 6. Respondent also requests that reasonable attorney's fees and costs pursuant to ARS 25-324 as a result of petitioner's noncompliance with the court rules, continued disregard for Rule 49 disclosure obligations, and her wholesale unreasonable behavior in bringing this litigation despite providing no verifiable proof she was ever pregnant. But Greg, she's going to give you her Banner Health login to see her P-stick results. Isn't that good enough? Wherefore, respondent respectfully requests the court A. schedule a 30-minute virtual status conference to address pretrial issues prior to evidentiary hearing scheduled for 2/27/24. B. Award respondent his reasonable attorney's fees and costs due to petitioner's unreasonable pursuit to ARS 25-324. C. Order such further relief as the court deems just. And then Woodnick signed it, and it was sent to the correct people. Here we have one of her Medium articles, or part of it. All right. From plea to persecution, the harsh reality of my appeal for justice. Oh my God. Well, she likes the dramatics, doesn't she? The aftermath of my article has unfolded in a manner I can scarcely believe, yet can't say I'm totally surprised by. The notion that I would be the mastermind behind threats of my own family defies logic. Does it? Because it seems to make sense. If you didn't do it, who did? And we know things are not beneath you. Sorry, I am uncomfortable today. Yet some have latched onto this theory with a fervor that's both bewildering and painful. Well, she's got her thesaurus and dictionary out, guys, when she's writing. There's nothing that will convince me she didn't concoct all this by herself, echoes a sentiment that feels like a knife twist, turning my quest for safety into an absurd spectacle. Another accusation hits. Yep, 100% catfished profile created by blank, by Owens. She is beyond sick. The speed which these unfounded claims spread is not just reckless, it's soul-crushing. Well, karma's a bitch. The personal attack that followed cut even deeper, warping my reality into something unrecognizable. It's hysterical that Owens thinks she can try to cover her tracks now with that fake profile. It's too late, Owens. And we also see clearly how you weaponized and used race to fit into your disgusting victim narrative. Such assertions are a bitter pill to swallow, particularly when contrasted with the diversity of my own family. My half-Asian nephew stands as a living contradiction to these baseless claims of racism. She just used the I have a black friend, so I can't be racist, basically. Oh my God. Okay. All right. I can't be racist. I have a nephew. Now, that doesn't mean you're not racist. That doesn't mean you're not pretending to be racist or trying to say that Clayton's being racist. Like, none of that means anything. The insinuation of deceit is relentless. Makes content creators sign a I will not incite violence clause, then days later drops an article about a content creator fan threatening her blank. There's nothing that will convince me that she didn't concoct all this herself. Accuses one commenter, suggests a calculated orchestration of events that couldn't be further from my truth. There is no such thing as my truth. There is such thing as the truth. There's no your truth, his truth, my truth, her truth. There is only the truth. There's only one thing that can be truthful. Your truth. So Amber Heard, my truth. My truth. Your truth doesn't mean it's necessarily the truth. It's a bizarre twist of fate where those who claim to seek justice are the very ones perpetrating injustice by pointing fingers at me without proof, by calling for the FBI to investigate me. She's actually committing federal crimes now by catfishing and posting death threats to herself. They are not only, and then we don't get any more. We are thinking out loud that if you can falsify documentations, lie about being pregnant to several people, lie about getting sonograms and seeing doctors, what won't you lie about? What won't you do? You already do the low of the low. And you are committing federal crimes. Fraud upon the court. And we have tons of proof. We're not doing anything without proof. We're not just saying, oh, look at this famous person. We have to believe him and not believe her because she's not famous and he is. That's not what happened here. In the beginning of the Gwyneth Paltrow case, a lot of people thought the famous person should just pay up. But then we saw evidence and said, oh dang, that's why Paltrow didn't pay up. I wouldn't either. We didn't just believe her and choose her side because she was a famous person. Because originally, people weren't really on her side. And then you see the evidence. And the evidence is where the truth, the story, actually is. The night things changed, I've been forced to break my silence. You were never silent. You started all this in the media. Last night something happened that I never imagined could be part of my reality. Threats against me and those I hold dear were articulated with chilling specificity and malice, all stemming from a smear campaign orchestrated by a content creator who has turned my life into a spectacle for profit. Crazy bleh. I'll find you and all my blank will shoot you. Justice for, I'm guessing something, name of content creator. One message read. Yeah, you could have done that. You haven't proven you didn't do it. Hand your laptop over to a forensic person. Or your computer, all your electronics, Owens. Hand them over to a forensic person. And then we'll see what the truth is. One message read, another ominously targeting my mother. These threats were not mere acts of internet cruelty. They were direct outcome of his relentless use of my story for financial gain. Yeah, except for most of your videos get demonetized on their channels. So, I don't know what they're making, but okay. The safety of my family, once taken for granted, is now compromised. But you did that, Owens. You did that. People shouldn't go out here doing this. If this is not her doing it, don't be doing this. This is not okay to do to anyone. Our lives overturned by a narrative spun by a total stranger. No. You did that with your lies. 6 months of turmoil. For 6 excruciating months, this content creator has been the conductor of a relentless smear campaign against me, pulling strings and painting me as the villain in a story so twisted from reality it's unrecognizable. But where is the proof that I'm going to say Dave Neal? Where's the proof that Dave Neal has made anything up? Videos about me at least once daily and sometimes more than that. He has leveraged lies sourced from those with vendettas against me, men I have restraining orders against, and told their stories as if they were the victims. That's what it seems like. That's what it seems like. This is what happens when you lie and are not honest, and you lose all credibility. That's why it's not worth lying. He spun these fabrications into hundreds of hours of content with each video, each post, not just an attack on my reputation, but a considerable source of revenue for him. Where's your proof of that? My attempts to seek help, including desperate 911 calls, have been obtained by his cult-like following and have been twisted into entertainment for audiences that revels in my distress. Hello to my culties. Hello, fellow culties. This relentless assault has devastated my mental health and halted my professional life. You did this. You did this to yourself. If you have nothing after this, you are to blame. Take accountability. His refusal to halt his attacks or remove the harmful content, my sole request, has left me with no choice but to pursue legal action for defamation, invasion of privacy, and intentional infliction of emotional distress. You inflicted that on yourself. You need to sue yourself. And I don't think that lawsuit worked out too well for you. But the real wake-up call came last night, proving that the stakes are far higher than reputational damage or court battles. This is about survival. And then her next paragraph is going to be a desperate plea. Stop using Medium as your journal, as your diary. Keep all these thoughts to yourself. Nobody cares. Go write emails to your parents. Go cry to your sister. Stop dear diarying all over the internet. And then we went over February 5th. Corey, it was nice seeing you Friday. Since we have not received the death certificates and the HIPAAs, I assume you agree with the motion to continue and request trial time. We've already seen this email. Corey, you have not responded to our motion to continue for additional time, nor have we received a written response. I'm guessing that you're having client control issues, as by her behavior in California and online, not including the recent bar complaints on your watch. I appreciate that Owens is going to refuse, contrary to law and court rules, notwithstanding lack of discovery, blah, blah, blah. Actually, please disclose a copy of your fee agreement by end of business tomorrow, along with the same from all of your prior counsel in this matter. Beretta and Platter, Lexi and Teresio, and others I may be forgetting because there's such a long list. Greg Woodnick. Corey, things just keep getting more ridiculous. My email, another article. She appears to be focusing her efforts on video journalist Dave Neal. I trust Dave is a big boy and he can deal with this nonsense, but her allegations against him after dismissing her ridiculous attempt at an injunction are concerning to say the least. She is now alleging that Dave somehow incited violence against her and that she is now facing death threats. Note, the few videos I have seen by Dave repeatedly condemn violence against Owens. Yeah. Don't do anything to her. Don't contact her in any way. Since Owens' bag of tricks tends to fit a pattern, we suspect the postings were a contrived ploy to yet again request a motion to seal. I appreciate that your client wants to view herself as a victim by the press, that she incited and continues to stoke with her articles, but these postings should be viewed with several grains of salt. We personally tried to find the alleged posting Should you be inclined to disclose it, it would be nice. As always, I'm happy to discuss this offline and appreciate that you may be having a client control issue. Here's the link to her most recent Medium article. The night things changed. And then that is Greg's email. All right. Now we have expedited motion to set virtual conference. And we go through this thing. And it says, accusation of fabricating a pregnancy and misconduct. Quote, petitioner initiated in the underlying action when she filed her petition alleging that she was pregnant with respondent's twins after only oral. Respondent has consistently maintained that this alleged pregnancy was entirely fraudulent. Potential violation. This could potentially violate Rule 4.1, truthfulness in statements to others, by making potentially unfounded allegations about the petitioner's honesty and intentions. Mr. Woodnick was not there the night that respondent and I hooked up and cannot make it seem like the fact that we had oral when that is not the truth. Well, we don't know any difference. And no, Woodnick was not there, and he's not stating he was there. He is saying by all the evidence beyond a reasonable doubt, that is what he thinks happened. Insinuating of dishonesty without proof. Quote, petitioner's only evidence provided in support of her alleged pregnancy has consisted of fake sonograms and positive HCG tests. Potential violation. This could infringe on Rule 8.4c, misconduct involving dishonesty, fraud, deceit, or misrepresentation, depending on the veracity and the intent behind these claims. Misrepresentation of facts to the court. Quote, no medical verifiable proof of pregnancy that would satisfy the requirements of Rule 2 has been provided. Potential violation. Rule 3.3a, candor towards the tribunal. If there is a suggestion that I am is lying without clear evidence. What? If there is a suggestion that I is lying without clear... This sentence does not make sense. I am is lying. Okay. Allegations of avoiding disclosure and manipulating legal processes. Quote, instead of providing basic discovery, she has filed bar complaints, board complaints, and sued journalists. Petitioner is claiming she cannot disclose records to respondent, but is publishing articles about the situation. Potential violation. Could be seen as a violation of Rule 3.3, candor towards the tribunal, if these statements are misleading or manipulate the legal process for an unfair advantage. I don't like these candor towards the tribunal potential violations that are being stated here, because they don't prove anything. Woodnick is not trying to mislead or manipulate the legal process and make it an unfair advantage. He is also not lying, and he has clear evidence that you are. So let's clear up your potential violations. Claiming petitioner's actions are sanctionable without sufficient justification. Quote, petitioner's sanctionable conduct and wholesale inability to support the fiction of her alleged pregnancy. Potential violation. Might violate Rule 3.1, meritless claims and contentions, if the claims of sanctionable conduct are not substantiated by evidence. Well, good thing they are. Personal attacks on petitioner's character. Oh, Lord. Petitioner attacked her petitioner's character. She attacked her own character by doing all this. Quote, for all respondent knows, the imaginary twins are buried at the horse ranch. That was the excellent burn by Greg Woodnick. A potential violation. This statement could be considered as violating Rule 8.4d, conduct prejudicial to administration of justice, as it seems to serve no purpose other than to demean me in a personal and distressing manner. Yeah, that's why it was a good burn. Because, you have your horse farm. Insinuation of unlawful behavior without proof. Lord. Quote, instead of providing basic discovery, she has filed bar complaints, board complaints, and sued journalists. Potential violation. 8.4d, conduct prejudicial to the administration of justice, suggests misuse of legal process without evidence. I have not filed board complaints nor sued journalists. To what? To what did you just say? Ma'am, we just went over your board complaints. Okay, board. Maybe not board complaints. Bar complaints we have. And sued journalists. Dave Neal is who he's talking about as a journalist. You sued him. That happened. But go on. Continue to lie. It's what you're known for. Disparaging remarks about petitioner's credibility, to which petitioner has none of. Quote, petitioner claiming that she had access to verifiable medical records to support her allegations of pregnancy, but then refusing to make them available. Potential violation. Rule 3.4e, fairness to opposing party and counsel. By suggesting I am not being forthcoming with substantial proof when I submitted it with my filings prior to Woodnick coming on. I have never refused to provide information. I just asked for a protective order because he has been releasing everything filed and every communication to the media, and I wanted to make sure he didn't do that with my medical records. You put them out to the public in a Dropbox link. He shared nothing else. Everything came from you. Get that through your head. Why is that so hard for you to understand? You did the action. You know what you did. And what he's talking about, refusing to make available, is the 80% redacted thing that you wouldn't show him unredacted. That you have, supposedly, to prove you were pregnant, but you won't show him. So no. You're not being forthcoming. Failure to maintain dignity and respect of the court. Quote, petitioner's perpetual disregard for court rules is exhausting. Potential violation. Rule 3.5d, impartiality and decorum of the tribunal. Though comments may undermine respect for the court's authority. No, he's just stating an opinion that this has been exhausting. And it's probably been exhausting for the judge to have to read all this junk. She's probably like, is she pregnant or is she not? Inappropriate commentary on legal strategy. Quote, petitioner now says she is no longer pregnant, but has failed to identify this as a result of fetal death or alleged babies have been put up for adoption. Potential violation, Rule 4.4a, respect for rights of third persons. By using sensitive personal circumstances to question my integrity or legal strategy is inappropriate. No, it's not. No, it's not. It's appropriate to ask, where are the babies? Where are the babies? Why are they no longer here? They've just disappeared. Dismissive reference to legal concerns. Full quote. Not even just a quote. We get a full quote. We get full quotes now, guys. The antics from petitioner continuing to proliferate, and it is clear from communication as appended the petitioner's most recently retained counsel, approximately the 12th in this series, is having challenges with client control and impact respondents' ability to access requested disclosure. As shown in docket, Mr. Corey Keith is my second attorney, not 12th. Notice he said in this series of cases, not just this case. Geez. Potential violation. Rule 3.4. Fairness to opposing party and counsel, suggesting a lack of respect for my legal concerns and diminishing the seriousness of my claims without due consideration. Inappropriate allegation of pregnancy fraud. Full quote. Petitioner's blatant refusal to provide any disclosure or engage in discovery must be addressed. Prior to the evidentiary hearing, during the nearly 7 months since initiating this action, petitioner's only evidence provided in support of her alleged pregnancy has consisted of fake sonograms and positive HCG tests. Potential violation. Arizona PC Rule 8.4c suggest misconduct involving dishonesty, fraud, deceit, or misrepresentation through unproven allegations of falsifying medical records. We've proved them. They've been proved now. So, violation dismissed. Debunked. Accusation of fabricating pregnancy and extortion. Full quote. This time, petitioner chose a television personality on which to perpetrate this fraud and not only faked the pregnancy, but attempted to extort him to date her in exchange of for an abortion of fictional twins. Potential violation. Rule 8.4c, as Mr. Woodnick accuses me of fraud and extortion without substantiated evidence, implying dishonesty and misrepresentation on my part. This obviously damages my reputation. Well, then stop being dishonest. Misrepresentation of medical evidence. Full quote. Petitioner was willfully and wantonly failed to provide any Rule 49 disclosure, respond to any request for production, and refused to attend a properly noticed Rule 57 deposition. Potential violation. Rule 3.4. Suggesting that I deliberately obstructed the legal process and discovery despite my compliance with the procedural rules and efforts to provide requested information. You have deliberately not complied because you didn't want them to know about you doctoring the sonogram image. You didn't want them to know that you hadn't been to any of those doctors you had talked about in your hearings. You didn't want them to know all that because it makes you look bad. But that's not Woodnick's fault. That's not Clayton's fault. That is your fault, Owens. Claim of fraudulent court behavior. Full quote. Petitioner then continued to contact the media, furthering her entire fraudulent fake pregnancy narrative. Potential violation. Rule 3.3. As Woodnick asserts, I perpetuated a false narrative to the media and court, challenging my candor towards the tribunal when I have been entirely honest. Debunked. Not true. Your deposition that you went to after all of this proved you have not been entirely honest. Misleading accusations of pregnancy fabrication. Full quote. Respondent maintains that this alleged pregnancy was a hoax/con, much like a previously litigated matter involving petitioner and other men similarly situated. Potential violation. Rule 8.4c, for suggesting without proof that I fabricated my pregnancy, indicating dishonesty, fraud, deceit, or misrepresentation. We have proof. So all this suggesting without proof, this Rule 8.4c, we didn't violate that because we have proof. It is with proof that we say this. Unsubstantiated claim of extortion. Full quote. This time, petitioner chose a television personality in which to perpetrate the fraud. Okay, we read that. Abortion of the fictional twins. Potential violation. Rule 4.1. For asserting without evidence that I attempted to extort someone under false pretenses. Well, you did. Oh my God, how many potential violations are there? Accusations of deceptive court behavior. Full quote. Petitioner, when appeared in court wearing ostensibly fake pregnant stomach, furthering her fraudulent narrative. Potential violation. Rule 8.4d. For claiming without substantiation that I engaged in deceptive behavior in court, prejudicial to the administration of justice. I did not appear with a fake stomach. Okay. Bad faith litigation. Full quote. Petitioner's baseless accusations and myriad filings have harmed him. Potential violation of ARPC Rule 3.1 regarding meritless claims and contentions by suggesting my legal actions lack legitimacy without evidence. Oh, they lack legitimacy with evidence. Somebody need to proofread this, because this is full of lies. Accusations without proof. Full quote. Petitioner's factual contentions and assertions of pregnancy not supported by any verifiable evidence from the onset of this action. Yeah, especially if you weren't pregnant in July. Potential violation. ARPC Rule 1.0 on maintaining integrity by accusing me of lying without presenting clear evidence. Okay, I'm not even going to respond. Just every time she says without clear evidence, just change that out for with clear evidence. Okay? Because that's what we have here. Claims of unreasonable filings. Full quote. Petitioner's repeated filings, including a motion to dismiss once she alleged she was no longer pregnant, being unsupported by existing law. Potential violation. ARPC Rule 3.1 on filing non-meritorious claims and contentions by alleging my motions are baseless when they are not. They are. I wanted to dismiss the case after I had a miscarriage since there was no longer paternity to determine. That is not true. Offensive and speculative remarks. Full quote. If impossible, from oral. Petitioner was actually pregnant, delivered twins, and or suffered a miscarriage post 24 weeks gestation. At any point during this process, she would have verifiable medical evidence. To date, no fetal death certificates have been executed, no confirmable medical evidence has been presented, and petitioner has continued to claim protection while reaching out to media directly. Oh, I can't wait to see what she says here. Potential violation. ARPC Rule 8.4d. Suggesting conduct prejudicial to the administration of justice through speculative and offensive remarks regarding the outcome of a pregnancy. This comment not only trivializes the serious matter of pregnancy and potential loss, but it also ventures into making unfounded and speculative assertions about highly personal and sensitive circumstances without substantiating evidence, which could be deeply distressing and seen as an attempt to demean or harass. And as stated before, Mr. Widnick was not there the night that respondent and I hooked up, and cannot make it seem like a fact that we had oral sex when that is not the truth. Okay, she wants to keep saying, well, Woodnick wasn't there. He doesn't know what happened. And I'm sorry, your highly personal and sensitive circumstances? You brought this matter into court, which means that Woodnick and Clayton get to see that highly personal and sensitive information that you don't want to turn over. We turned over Mom Doc finally, which just states not pregnant. And you didn't give her all the facts either. You lied about your pregnancy history. You've lied somewhere because you can't keep your lies and dates straight. That must be hard, though. I mean, you've been doing it for 10 years. Inflammatory and disrespectful remarks. Full quote. For respondent knows the imaginary twins are buried at the horse ranch. Okay, why do we keep bringing up the same ones? Because they're different rules. The violations are different. ARPC 8.4D, suggesting conduct prejudicial to administration of the justice through use of insensitive and speculative language about highly personal matters. Full quote, her petition was predicated on either lies or delusions and mirrors prior to litigations involving Owens and a growing list of other victims. Potential violation. The rule prohibits conduct involving dishonesty, fraud, deceit, or misrepresentation. Mr. Woodnick's definitive statement that my entire petition is based on lies or delusions directly accuses me of fraudulent and deceitful behavior, without prefacing these allegations as opinions or unproven claims. His failure to use qualifiers like allegedly suggests an unusual certainty that's in these serious accusations, which could be seen as a direct attack on my character and integrity. The men that he refers to as my victims are men that I have orders of protection against, which you have one against Clayton that should never have been granted. So, excuse us for not taking your other orders of protections seriously. You lied in this one. You probably lied in those. Rule 3.1, Meritless Claims and Contentions. Explanation. Attorneys must not bring or defend a proceeding or assert or convert an issue therein unless there is a basis in law and fact for doing so. This is not frivolous. By stating without qualifications that my petition is based on lies and delusions, Mr. Woodnick not only dismisses the legitimacy of my claims without fair evaluation, but also implies that my legal actions are entirely without merit, potentially misleading the court. We'll see what the judge thinks, because it is his belief that he has evaluated the situation, and nothing you have done has proved otherwise. So he's allowed to state his view. Rule 3.4E, Fairness to Opposing Party and Counsel. Explanation. This rule underscores the importance of respect towards the legal rights of others. The direct and unqualified manner in which Mr. Woodnick discredits my entire petition goes beyond legal argument into the realm of personal vilification, which is contrary to the spirit of fairness and civility mandated by the ARPC. He has a right to call you out in his motions. Call out your behavior. Call out that you're not providing things and you have not provided proof. He has the right at this point to do this. Rule 4.4a, Respect the rights of third persons. Explanation. In representing a client, a lawyer must not use means that have no substantial purpose other than to embarrass, delay, or burden a third person, or use methods of obtaining evidence that violate the legal rights of such person. Mr. Woodnick's assertion about my petition being based on lies and delusions can be seen as an attempt to embarrass or burden me, rather than a constructive legal argument. He has tried legal arguments with you. He asked for a deposition you didn't come to. He has asked for you to comply with discovery. He has asked for fetal death certificates. He has asked and asked and asked, and nothing has been given. So why can he not say that you haven't done these things when you haven't? And you are nothing but lies and delusion, Owens. Rule 8.4D, Conduct Prejudicial Administration of Justice. Explanation. Lawyers are prohibited from engaging in conduct that is prejudicial to administration of justice by categorically stating that my petition is found on fabrications and likening it to past litigations in a manner that suggests a pattern of deceit on my part. Mr. Woodnick's comments could be interpreted as undermining the judicial process and prejudicing the court against me without due cause. There is a pattern. There seems to be a pattern. And the judge, I don't know that she's going to be prejudiced. Anyways, derogatory speculation and accusation, full quote. Simply by petitioner's pregnancy was faked. The bump displayed by Judge G. Courtroom was substantially purchased as evidenced by petitioner clearly adjusting what appears to be a fake belly and guzzling a Monster energy drink. Curious for somebody claiming to be pregnant. Potential violations. We have Rule 8.4D. Conduct prejudicial to administration of justice. This statement not only questions the veracity of my medical condition in a derogatory manner, but also implies deceit in a way that could be prejudicial. Rule 4.4a regarding the respect for my rights of third person mandates that a lawyer shall not use means that have no substantial purpose other than to embarrass, delay, or burden. The remarks about the pregnancy being faked and the condescending tone regarding consumption of a Monster energy drink could be seen as intending to embarrass or demean me, which is inappropriate. It's meant to be the truth. Rule 3.4e, on fairness to opposing party and counsel, which obligates lawyers to refrain from making unfounded allegations that do not have a factual basis. The assertion that the pregnancy was faked without providing concrete evidence directly undermines the principle of fairness in litigation. I don't think Woodnick would be saying this without evidence. He clearly has stuff to back up his statements. Otherwise, he wouldn't be saying them. So, they are not unfounded. Alright, now she's going to go into the expedited motion to continue trial and motion for additional time. Unsubstantiated claims of extortion. Not only faked the pregnancy, but attempted to extort him to date for the exchange of abortion of fictional twins. Potential violation. Such a serious accusation without evidence could breach Rule 8.4c, suggesting, okay, we already know that. Inappropriate comments on court appearance, full quote, she appeared on video wearing an ostensibly fake stomach. Potential violation, this could contravene 8.4d, which prohibits conduct that is prejudicial, making unfounded personal attacks within a legal document. No, we're just stating what appears to be true. Derogatory speculation on medical conditions, full quote, petitioner's HCG test proved nothing, and her reliance on them when she could provide simple and basic evidence begs many questions about her credibility and motivations. Yeah, it does. But, like, he can say that because that's all he has. But you want to give him... Good thing you're not writing out tickets, because you don't understand anything. Potential violations. The speculative and demeaning comment could be seen as a violation of 8.4d for conduct that is prejudicial to the administration of justice, and Rule 4.4a regarding respect for the rights of third parties. An HCG test is what any doctor uses to test for pregnancy. That's the starting test. Then there are further verifiable things, because they do need to find out if it's an ectopic pregnancy or a viable pregnancy. What figures that out? An ultrasound. They also need to do a blood test to see that your HCG levels match what a pregnancy is. Yours did not, ma'am. Unfounded allegations of court misuse. Full quote, petitioner's behavior in this litigation is unreasonable and predicated on bad faith such that respondent should be entitled to his reasonable attorney's fees and costs. She's probably like, huh? He needs to pay my attorney's fees. potential violations, claiming bad faith litigation without substantiation, which he doesn't have. I have ample proof of pregnancy, as even provided to you, could violate Rule 3.1 for asserting claims without merit and potentially Rule 8.4.c for suggesting dishonest conduct. You are the one that is conducting yourself dishonestly. Violate yourself. Okay, no, I take that back. That sounded really bad. Please don't violate yourself. That's gross. Moving on. Disregard for petitioner's rights. Full quote. Petitioner wanting to be pregnant and being pregnant are two different things. They are, in fact. Potential violations. This statement could violate Rule 4.4a by disrespecting my dignity and personal situation, and Rule 8.4d for potentially prejudicial conduct. No. No, no, no. He's just stating they are different things. There is nothing wrong with stating that. Defamatory statements about legal motivations. Oh, Lord. She just can't help herself. Full quote. Her entire petition was predicated on either lies or delusions and mirrors prior litigations involving Owens and a growing list of other victims. Potential violations. This could infringe upon Rule 8.4c by alleging dishonesty without evidence, and Rule 8.4d, prejudicial administration, making personal attacks, and illegal filing. The men that he refers to as my victims are men I have ordered. Okay, we've already done that one. Okay, something I'm also going to put in at the end of this is I did not put in the Lexi Linval stuff on the bar complaint stuff, so I'm going to put it in here. So it says immediate assistance and guidance needed in response to ethical concerns and intimidation in a legal case, dated Sunday, January 7th, 2024. But you didn't make complaints. To be fair, they're bar complaints, not board complaints. I don't know what board she would have gone to. But, dear Arizona State Bar, I am writing to you under circumstances of extreme urgency and distress relating to my ongoing paternity case and the conduct of two attorneys, Mr. Greg Woodnick and Miss Lexi Linval. Due to the immediate nature of the issues at hand, particularly an upcoming deposition on the 17th, I am unable to follow the standard procedure for filing a formal claim and thus seek your immediate intervention via this communication. Background. My paternity case involving Mr. Clayton Echard was initially heading towards dismissal after my miscarriage. No, it wasn't. Just because you think it was doesn't mean it actually was. With both parties self-represented. However, the trajectory of this case shifted drastically when Mr. Woodnick entered the case as soon as it appeared on the dismissal calendar, his involvement seemingly motivated by a personal vendetta against me based on a prior case, has added contentious and distressing dimensions to the proceedings. In a call that I am attaching, Miss Linval explains to me after her first phone call with Woodnick that this case is personal for him, and describes how he and his co-counsel Isabel Rainey were yelling at her on the phone. Context of innocence and ethical implications of Miss Linval's actions. I have provided incontrovertible evidence of my pregnancy. No, you haven't. To Miss Linval. No, you haven't. Access to my Banner Health portal. Oh my God. Say Banner Health patient portal one more time. Nobody wants to see it. It's just a pea stick that says you have HCG. Despite this, she pressured me into signing a falsely declaring that I was never pregnant with Mr. Echard's child. You didn't have to sign a document that said you weren't pregnant. You signed that. That is your own fault. You're a grown adult. Take accountability for your actions. I repeatedly refused, and our attached call conversation represents a clear ethical violation, particularly under Rule 1.2d, Scope of Representation and Allocation of Authority Between Client and Lawyer. She also encouraged me to sign the same affidavit after that conversation in the attached email correspondence. Her insistence of this false declaration and her subsequent decision to withdraw under threat of Rule 3.3 filing have left me vulnerable state without representation when there are many filings that need to be responded to very soon. Additional ethical violations by Ms. Linval. Rule 1.4, Communication. Her failure to properly communicate the implications and alternatives to her withdrawal and the advice she provided might also constitute a violation of duty to communicate effectively with the client. Rule 1.16, Declining or terminating representation. Her decision to withdraw from representation seems to conflict with the responsibilities outlined in this rule, particularly ensuring that the client is not unfairly impacted by the withdrawal. She probably found out the truth. Linval probably found out the truth and said, you need to sign this. And if you don't sign this, I can't continue to represent you. Because I can't go on saying that you were pregnant when I know you weren't. And that's probably what it was. And I'm sure Miss Linval has probably explained something to them. Mr. Woodnick's unwillingness to allow extensions as a potential violation. Mr. Woodnick's refusal to grant an extension for the deposition, especially given the pending motion to dismiss and the motion to quash the deposition, may constitute a violation under Rule 3.4d, Fairness to Opposing Party and Counsel. This refusal has obstructed my ability to secure new legal representation, further disadvantaging me in this case. But you ended up having Corey Keith prior to that. Maybe after this email, but it was prior to your deposition date. So you would not. You had legal representation. You could have gone. It wouldn't have been a disadvantage. You wanted to push this out further. Woodnick doesn't have to grant extensions. You want an extension? Go to the judge. Having interviewed several attorneys who would love to take on the case but are unable to simply because of the tight deadlines that Ms. Linval has left me with to respond to numerous motions and Mr. Woodnick's refusal to extend any of them. One of the petitional attorneys I spoke to said that I should reach out to the Arizona bar for assistance. Yeah, probably to ask if they knew of attorneys or something that could do this. Not to complain and get them to come into a litigation that is ongoing. Excuse me. Ethical violations by Mr. Greg Woodnick. Concerns under Rule 3.4d, Fairness to Opposing Counsel and Party. His refusal to grant an extension for deposition, especially with the pending motion to dismiss and quash the deposition, has significantly disadvantaged me in securing new legal representation. Once again, go to the judge. The judge would probably give you an extension. Woodnick doesn't have a say. He is going to go by what he has lined up, because that stuff is already paid for. Rule 8.4, Misconduct. Mr. Woodnick's conduct, particularly his refusal to provide extensions and his aggressive communications, might be construed as conduct prejudicial to the administration of justice. Oh my God, shut up. Potential violation of Rule 4.4a, Respect for the rights of a third party. The aggression and the personal nature of Mr. Woodnick's legal communication appears to be aimed more towards harassing and intimidating me than any legitimate legal strategy. Fear and panic regarding the up-and-coming deposition. The prospect of facing a 4-hour deposition without legal representation is daunting. Given the emotionally charged nature of this case, including the context of my miscarriage, I am deeply concerned that this deposition is being used as a tool to further intimidate and harass me. Ma'am, most cases have depositions. They are not used for intimidation or harassment. They are used for discovery. Urgent request for guidance. To demonstrate my innocence and refute claims that I have falsified pregnancy, I'm providing the login. What did I say? What did I say? Do not say Banner Health patient portal login one more time. Shut up about it because it proves nothing. Nobody cares. Where evidence of my pregnancy confirmed in June is available. Given the immediate nature of this situation, I am seeking advice on immediate steps I can take to address these issues and secure my legal rights, particularly concerning Mr. Woodnick's refusal to provide extensions. Go to the judge. I appreciate your prompt attention and awaiting your guidance on navigating these challenging circumstances. Sincerely. Oh, what's sincerely to them? Maybe you should have told them all the best. And then external email, think before you act. Oh my God. Okay, so that is an email that I did not include in the sanctions thing. And here is, and then we are going to end the video for today. Thank you for staying through this video. It was kind of a rough one. Our quote of the day is law of karma. Never try to play with other people around you, for you may never know that they play better than you. Don't hate the player, hate the game. You tried to come and play. But you struck out. Because you found people that play better. They don't play with people like you. Please like and subscribe, and I will see you later.